All right, we're getting started with our afternoon breakout session. Thank you all for being here. This afternoon breakout session is entitled The Courtroom Where It Happens, Role of the Federal Judiciary as an Arena for Civil Rights and Racial Justice. And I just want to personally thank our panel for being here. I'm going to introduce each one of them in a second. But it means so much to all of us here in Rhode Island that you would come and be here with us, share your thoughts with us. We have such a talented panel, as you'll hear about in just a minute. I wanted to just read to you the first paragraph of the brochure for this session to give you an overview of where we're going to be going. The arc of the moral universe is long, but it bends towards justice. The federal judiciary has played an integral role in bending the moral arc of our nation toward justice. It is the forum where battles for change to the oldest and deepest rooted prejudices in our country's history are waged. It is the forum where those continuing to deal with the prejudices and biases of our time enter to seek justice. Although all men and women are created equal, when they are treated disparately, the federal courts are the venues where individuals seek justice. So I'd like to introduce our four panel members. First is Professor Cara McClellan. Cara McClellan is the Director and Associate Practice Professor for the Advocacy for Racial and Civil Justice Clinic at the University of Pennsylvania Carey School of Law. The ARC Clinic provides students with hands-on experience working in civil rights litigation and policy advocacy around systemic racism. Professor McClellan previously served as assistant counsel at the NAACP Legal Defense and Education Fund, where her work focused on education equity and ending the criminalization of Black people. Professor McClellan has represented students and families in school desegregation cases, such as Sheff versus O'Neill, and students and alumni as amici in SFFA versus Harvard, defending Harvard's affirmative action admissions policy. She earned her undergraduate degree from Yale, a master's in education from Penn's Graduate School of Education, a JD from Yale Law School. Following law school, she clerked for the Honorable Gregory Sleet, who was the Chief Justice of the U.S. District Court for the United States District Court for the District of Delaware, and the Honorable Andre M. Davis, Senior Judge for the United States Court of Appeals for the Fourth Circuit. So please let us welcome Cara McClellan. Our next panelist is the Honorable Leslie Abrams Gardner. Judge Gardner is United States District Court Judge for the Middle District of Georgia. On March 11th, 2014, President Obama nominated her to the bench. And on November 18th, 2014, the Senate confirmed her by a vote of 100-0. On November 21st, 2014, Judge Gardner took the oath of office and became the first female federal judge in the Middle District of Georgia and the first African-American woman to become an Article III judge in the state of Georgia. Judge Gardner received her bachelor's degree from Brown University, so this is home to her as well. That was in 1997, and received her JD from Yale Law School in 2002. Judge Gardner clerked for the Honorable Marvin J. Garbus in the District of Maryland, and then joined the DC office of Skadden Arps. In 2010, Judge Gardner became an assistant U.S. attorney for the Northern District of Georgia, where she prosecuted major crimes, white-collar crimes, and worked as the community outreach coordinator until being elevated to the bench. So let us please welcome Judge Gardner. Our third panelist is Professor Suzette Malveaux. Suzette Malveaux is a Moses Lasky Professor of Law and Director of the Byron R. White Center for the study of American constitutional law at the University of Colorado Law School. She is a member of the American Law Institute and chair of the American Association of Law Schools Civil Procedure Section. She has taught in areas of civil procedure, complex litigation, employment discrimination, civil rights, constitutional law for almost 2 decades. Professor Malveaux's scholarship explores the intersection of civil rights and civil procedure and access to justice issues. Professor Malveaux graduated magna cum laude from Harvard University. She earned her JD from the NYU School of Law, where she was a Root Tilden Scholar, associate editor of the Law Review, and the Center for International Law Fellow. Professor Malveaux was a class action specialist and civil rights attorney prior to becoming a professor. For 6 years, she served as pro bono counsel for the plaintiffs in Alexander versus the state of Oklahoma, a constitutional lawsuit filed against Tulsa by the victims of the 1921 Tulsa Race Massacre. Professor Malveaux also represented over 1.5 million women alleging gender discrimination against Walmart. So please let us welcome Professor Malveaux. And last but not least, we have Ezra Rosenberg. Ezra Rosenberg is co-director of the Lawyers Committee for Civil Rights Voting Rights Project, overseeing its voting rights litigation. So he doesn't have a lot going on right now. This includes a robust portfolio of over 110 cases in which the Lawyers Committee has participated in over the last 7 years. Mr. Rosenberg has tried several of these cases, including successful challenges to Texas voter ID laws and the Trump administration's attempt to add a citizenship question to the 2020 census. He is currently litigating challenges to Georgia and Texas's redistricting plans and those same states' laws altering certain voting requirements enacted in 2021. Prior to joining the Lawyers Committee staff, he was a partner at Deckert LLP. Mr. Rosenberg began his career with the New Jersey Department of the Public Advocate, focusing on special project criminal appeals, arguing several times before the New Jersey Supreme Court, including a landmark case that set the standard for judicial review of prosecutorial denials of pretrial diversion. He joined the Lands and Natural Resources Division of the United States Department of Justice, where he worked from 1979 to 1982, and he handled a variety of cases relating to the nation's lands. Mr. Rosenberg graduated from the University of Pennsylvania in 1971 and from New York University School of Law in 1974. Let us please welcome Ezra Rosenberg. So we're going to start off today with a presentation from Cara McClellan. We're going to go about a half hour, take a 5-minute stretch break, and then we'll hear from the rest of the panelists. Cara.
Good afternoon, everyone. I guess I want to start by just acknowledging that I have no business speaking after Attorney Fred Gray. I first heard him speak when I was an intern at the NAACP Legal Defense Fund. And as you heard, he was a cooperating attorney at the NAACP Legal Defense Fund for decades. But I think you also heard, his work really shows that cooperating attorneys are the leaders of the organization. They're on the front lines, they're the leaders in their community, and they also are the folks who have to have the courage to be there and be present physically after a case gets litigated, which, as his book really details, takes a lot of strength. So I first want to just say thank you for the invitation to be here today, and thank you to the Rhode Island District Court for holding this conversation and this conference on such an important and timely topic, which also really takes courage to take on. I was asked to speak on the role of judges in ensuring that our country lives up to the principles of equality and justice. My work as a law clerk, civil rights litigator, and more recently as a clinical professor has led me to deeply appreciate the critical role that judges at all levels can play as the keepers of our democracy. In my view, a courageous judge is one who does not shy away from talking about complex and deep-seated problems of racial injustice, but instead grapples with the ways that race shows up in the record and in the historical background of a case. I'm going to talk a little bit about the idea of a colorblind constitution, which we've already had during the critical race theory panel for those who are able to join for that. True experts speak on that topic, so I won't take the time to introduce it, which they've already talked and have written about incredibly deeply, and which obviously informs this discussion. But I'm going to try to provide some historical background for our conversation, but also just to provide a context to talk about some of the cases being litigated before the Supreme Court today. So I'm going to speak mostly from the perspective as a litigator. And the basic thesis I want to offer you today is that a racial analysis of facts and law is often required under the plain text of the Constitution, and is therefore a key aspect of the oath judges take to uphold the Constitution. In contrast, the concept of a colorblind constitution is an ahistorical notion that turns the purpose of the Reconstruction Amendments on its head by preventing courts from remedying racial inequality. So to illustrate this point, I want to offer a few examples from our country's founding and from our country's second founding during Reconstruction, and then I want to consider the ways that it's really showing up in cases today. So as early as 1619, when 19 enslaved black men were first brought to this country, courts became deeply involved in an explicitly race-conscious analysis of legal rules and principles. Courts were routinely asked to interpret laws that defined who was black, as we talked about earlier, and thus enslavable, laws that prohibited black people and immigrants of color from becoming citizens or voting, laws that prohibited black people from owning or inheriting property, laws that defined what constituted a crime based on the victim's race and the defendant's race, laws that prevented black people from bringing legal actions or testifying in court, and myriad other societal regulations. In short, courts were responsible for upholding a system of slavery and racial apartheid that was backed by law. The Constitution, as originally adopted, was explicitly race-conscious. In 1787, delegates to the convention in Philadelphia tasked with establishing a plan for determining states' representation in the US House of Representatives debated how the Constitution should treat black Americans in relation to white citizens. Southern states sought representation apportioned by population. Northern states pushed back from that position given the electoral and representational power Southern states would gain if black people were counted as part of their populations. And James Wilson of Pennsylvania proposed a 3/5 compromise, which became Article 1, Section 2, Clause 3 of the Constitution, and assigned a black person 3/5 the count of a white person in determining political representation in the House. As Supreme Court Justice Thurgood Marshall later wrote, and I'm quoting, "The effects of the framers' compromise have remained for generations. They arose from the contradiction between guaranteeing liberty and justice to all and denying both to Negroes." And then the different treatment that subordinated black people was further entrenched by the Supreme Court in the infamous Dred Scott v. Sanford decision in 1857. In which the court clarified that under the Constitution, black people, whether freemen or slaves, could not be considered American citizens. Writing for the court, Chief Justice Taney concluded that, and in the eyes of the framers, slaves, and I quote, were not included and were not intended to be included as citizens. And thus, under the Constitution, a black man had, again quoting, no rights which the white man was bound to respect, and might justly and lawfully be reduced to slavery for his benefit. As the late Judge Higginbotham observed, part of the tragedy of the Dred Scott decision is that the court reached a constitutional holding mutilating the options of blacks while relying partially on inaccurate historical data known by the court to be false. That is to say, by the time of the Dred Scott decision, there were in fact laws that protected black people in some states, and most notably states that had already banned slavery or adopted systems of gradual emancipation, as was the case here in Rhode Island. So Chief Justice Taney's denial of the abolitionist work in progress only added insult to injury. On January 1st, 1863, Abraham Lincoln issued the Emancipation Proclamation, an executive order that all enslaved persons in Confederate territory were declared to be forever free. This painting by artist Thomas Nass was created for Harper's Weekly at the time to depict the promise of the moment. And I think it really symbolically depicts what was going on at the time in the minds of recently freed people. So in the middle, you have a black family seated around a Union stove. In the bottom, you see a baby breaking the shackles of a kneeling slave. And then on the scenes on the left and the right, try to create a dichotomy, right? The left depicts the inhumanities of slavery, whipping, branding, the separation of families, and then it's contrasted with what was seen as the promise of the moment on the right, showing freedom to work and receive payment, to marry and have familial autonomy, to go to school and to participate in democracy. So in 1865, the 13th Amendment officially banned slavery. This made the 3/5 clause nearly irrelevant, but not entirely, as slavery was still permitted for those sentenced for a crime of penal servitude. And therefore, these people were still under the jurisdiction of the 3/5 compromise. Resistance to the 13th Amendment and use of the loophole came swiftly. In 1865 and 1866, state legislators in the Deep South passed laws known as Black Codes that restricted the movement, property, voting rights, and education rights of black people. So all of the dreams that were in the promise of the moment were under attack. Recently freed slaves were often returned to conditions of forced labor through indentureship, sharecropping, and convict leasing. And this photo is from the Library of Congress. So in response, Congress passed the Civil Rights Act of 1866, which defined black men as citizens. The principles of the Civil Rights Act of 1866 were later codified in 1868 under the 14th Amendment, which constitutionalized birthright citizenship, provided for protection of life, liberty, and property to all persons against deprivations based on due process, and guaranteed equal protection of the laws. Section 2 of the 14th Amendment finally fully superseded the 3/5 clause when it provided that representatives shall be apportioned counting the whole number of persons in each state. So my point here, in short, is that the Constitution, as readopted during Reconstruction, was designed to respond to the ways that black people had been classified as inferior under the law and to address attempts to resubordinate and re-enslave black people after slavery had officially ended. This was further documented in the 1866 report of the Joint Committee on Reconstruction and in the legislative history and debates at the time of the passage of the Civil Rights Act and each amendment. So the invention of a colorblind constitution occurred largely through the decisions of judges to interpret it as such, at times in direct contradiction with Congress's express intent. And this started as early as 1883 in the civil rights cases. These cases involved the claims of black people denied accommodations in a hotel, in a train, in a dress store, and in an opera house in Kansas, and Missouri, and Tennessee, in California, and New York, respectively. So you can really see that by this point, segregation had spread across the entire country. Writing for the 8-justice majority, Justice Joseph Bradley held that the Civil Rights Act of 1875 exceeded the scope of equal protection under the 14th Amendment, which the Supreme Court held applied only to actions taken by state actors and not private individuals. As we heard about, notably, Justice Bradley questioned the need for any remedial legislation under Congress's power to legislate under the Reconstruction Amendments, because, as he put it, formerly enslaved people could not continue to be the special favorites of the laws. Reacting to the decision, Frederick Douglass observed, the court had constructed the Constitution in defiant disregard of what was intended by Congress. The Philadelphia Inquirer reported that the court had practically overturned the constitutional amendments. The white Republican Robert G. Ingersoll stated that the court had undervalued the 14th Amendment such that the laws became colorblind. More generally, the court adopted an approach that willfully disregarded the real-life impact of segregation and the ways it was designed to subordinate black people and maintain white supremacy. This is actually a picture I took over the summer when I was in New Orleans. And if you're in New Orleans, you can see the actual train stop where Plessy was arrested. So we know that in Plessy v. Ferguson, the court was asked to decide whether a Louisiana law that required that all railway passenger cars be segregated by race violated the 14th Amendment. The 8-justice majority concluded that enforced separation of the races neither abridges the privileges or immunities of the colored man nor denies him the equal protection of the laws within the meaning of the 14th Amendment. In reaching this conclusion, the court disregarded the violence that was used to uphold segregation. In dissent, Justice Harlan invoked the idea of a colorblind constitution to argue that the 14th Amendment prohibited de jure segregation. But as we heard about this morning, at the same time, he described the ways that even with a formal equality principle, the status quo would be maintained, which is to say that at the same time he dissented, he also recognized that in his view, the white race was the dominant race in this country and would continue to be in prestige and achievement and education and wealth and in power. So explicitly, he endorsed white supremacy while also acknowledging that it could coexist with a formal principle of equality. It would take over 80 years for the court to switch course from the civil rights cases, and it would take over 55 years, including decades of strategic work by attorneys at the NAACP Legal Defense Fund, before the court in Brown v. Board overturned de jure segregation in public schools, concluding that separate is inherently unequal. I know that the district court read unexampled courage, and I just want to point out that the courageous dissent of Judge Waring in Briggs v. Elliott, one of the 5 companion cases that became Brown v. Board, was the first dissent from Plessy since Justice Harlan's dissent. In Briggs, the state of South Carolina, under advice from its attorney, resolved that because it could not realistically mount a defense that its racially segregated public schools were equal, it would instead admit liability and issue a massive $75 million bond to provide resources to segregated black schools and to avoid integrating. This was the cost of maintaining segregation that citizens were willing to take on. In his dissent, Judge Waring called out the state's attempt to convince the court to avoid directly addressing the issue of race, an invitation which the court had readily accepted. Judge Waring wrote, "It is the duty of the court to meet these issues simply and factually and without fear, sophistry, and evasion." He further observed, "It's clearly apparent the 14th Amendment's chief purpose, perhaps its only real purpose, was to remove from Negroes the stigma and status of slavery and to confer upon the full rights as citizens." So Judge Waring's decision would go on to become a roadmap for the Supreme Court in concluding in Brown v. Board that separate was inherently unequal, recognizing that racial segregation subordinates black people by imposing a badge of inferiority and denying full citizenship. But still, today, the invention of a colorblind constitution continues to do powerful work in reframing actions taken to remedy racial inequality as somehow in conflict with the purpose of the Reconstruction Amendments. Colorblindness is the basis upon which advocates ask the Supreme Court today to ignore or avoid addressing pervasive and deeply entrenched structural racism in many aspects of American life. Earlier this month, the Supreme Court heard arguments in Merrill v. Milligan, a case that will decide the future of Section 2 of the Voting Rights Act. Section 2, as we'll talk more about, bars election practices that result in denial or abridgment of the right to vote. And it's explicitly based on race. At issue in Merrill is the state's decision to draw congressional redistricting maps in ways that split the county and city of Montgomery into 2 districts and divides up what is known as the Black Belt in Alabama, a historically black, low-income community that is shaped by de jure segregation. The result of the maps that Alabama has drawn is that there is only one majority black district in the state, despite the fact that 27% of Alabamians are black. And as we also heard about earlier from Attorney Fred Gray, the state has a long, well-documented history of discriminating against black voters. This is the place where Gamillion arose from, where Bloody Sunday occurred, and in 5 of the 6 redistricting cycles since 1960, the Department of Justice or federal courts have found that Alabama's legislative districts, congressional, state, or both, have violated the rights of voters under the US Constitution or the Voting Rights Act. Arguing for the state of Alabama, Edmund LaCour advocated for the justices to adopt an interpretation of Section 2 that would allow a state to ignore race in redistricting, and thus prevent the state from directly remedying inequality and the ability of people of different races to elect the representative of their choice. Mr. LaCour argued that if a state draws a redistricting plan in a manner that is race blind, that does not violate Section 2, because in his view, this constitutes treating everyone equally. Instead, he argued that by seeking to remedy vote dilution, Section 2 was, and I'm going to quote, at war with itself and the Constitution, simply because acknowledging race is necessary to addressing inequalities based on race. Justice Ketanji Brown Jackson questioned the basis for Mr. LaCour's analysis as a matter of history. And I want to play for you that exchange if folks have not heard it already. So we'll talk a little bit more about Merrill in our panel discussion. But I want to point out, secondly, that a colorblind interpretation of the 14th Amendment is also at the heart of a pair of lawsuits the Supreme Court is hearing this term, called Students for Fair Admissions, or SFFA, v. Harvard, and Students for Fair Admission, v. UNC. In these cases, the plaintiff organization, SFFA, has asked the Supreme Court to rule that race may not be considered as a factor in university admissions at each school, respectively. During my time at the NAACP Legal Defense Fund, I worked on the legal team representing students and alumni in the Harvard case at trial and on appeal. While in the lower courts, SFFA advanced a theory that Harvard's admissions process discriminates against Asian American applicants, SFFA's brief before the Supreme Court focuses on its argument that the Supreme Court should overrule Grutter v. Bollinger and hold that institutions of higher education cannot consider race as a factor in admissions. Under controlling precedent, Supreme Court precedent says that a university may consider race as part of its admissions process, so long as it is narrowly tailored to serve a compelling government interest. Instead, SFFA argues that any consideration of an applicant's race should be prohibited under the 14th Amendment and, by analogy, Title VI, and that it is per se discrimination. SFFA seeks, and I'm going to quote because this is really quite striking language, in their complaint they seek a permanent injunction requiring Harvard to conduct all admissions in a manner that does not permit those engaged in the decision process to be aware of or learn the race or ethnicity of any applicant. So think about what that would mean and how far-sweeping that is. I mean, potentially it could mean that you can't even find out what school an applicant goes to, because a lot of times schools are racially segregated. But certainly it means that applicants can't talk about their race in their essay, can indicate that they're affiliated with affinity groups that would lead Harvard to figure out their race. That's the relief they've asked for in both cases. To understand why the plaintiffs have sought this relief, it's necessary to understand the roots of the plaintiff organization, SFFA. SFFA was founded by Abigail Fisher, who many may remember was the plaintiff in Fisher v. Texas, the last challenge to race-conscious admissions to reach the Supreme Court. After her attempt to challenge the law was unsuccessful, she teamed up with Ed Bloom, who is actually the architect behind Shelby County v. Holder, a successful attempt to really gut the Voting Rights Act. And he has been on a crusade in many areas of the law to ensure that race cannot be considered and that there can be no race consciousness. So together they founded this organization, and I'm just gonna let him speak for himself This is a video of him speaking at a meeting.
That's the goal of these lawsuits, is to eliminate the consideration of race or ethnicity in line. So, I needed plaintiffs. I needed Asian plaintiffs. And finding plaintiffs to challenge the Ivy League admissions policies, Harvard in particular, is not an easy thing to do. So I started, designed 3 websites: harvardnotfair.org, UNC, University of North Carolina, notfair.org, and uw.fair.org, University of Wisconsin.
So I'm just going to let his words speak for themselves, but I think it's clear when you see that that the race-blind approach that Abigail Fisher and Ed Blum are seeking is exactly in line with the work and the agenda that they've been pursuing for decades. In its brief before the Supreme Court, SFFA advocates for the creation of a colorblind constitution by arguing that it's required by the 14th Amendment and Title VI. And this is taken directly from their brief. They write, "Because Brown is our law, Grutter cannot be. Just as Brown overruled Plessy's deviation from our colorblind constitution, this court should overrule Grutter's. That decision has no more support in constitutional text or precedent than Plessy." But in stark contrast with the colorblind view advanced by SFFA, data shows that race continues to have a significant impact in structuring opportunity in students' K-12 educational experience in this country. In particular, Black students today are 6 times as likely as white students to attend a high-poverty school. Nearly 75% of Black K-12 students attend racially segregated schools, and racially segregated schools continue to be schools that have disparities in resources. High schools with high Black and Latino enrollment are also less likely to offer advanced math and science, and that's based on data from the Department of Education. Black and Latinx students are 2 times as likely as white students to attend a school where more than 20% of the teachers have not met state certification or licensing. Judicial decisions that rely on colorblindness and omit a racial analysis of facts and law are not only an erasure of history, but a denial of the real lived experiences of people of color. In her 1989 article, Law as Microaggressions, Professor Peggy Davis famously wrote that judicial decisions that ignore the racial context introduced in the record or in the background of a case, and I'm going to quote, strike the Black reader of law as microaggressions, stunning automatic acts of disregard that stem from unconscious attitudes of white superiority and constitute a verification of Black inferiority. So the real world impacts of colorblindness are not just in terms of the historical record or in the particular case, but also have ramifications in terms of the legitimacy of a court that is actually denying real life experiences of real people. In closing, today as much as ever, our country needs courageous judges who will not close their eyes to constitutional history and social reality, even when addressing racial inequality feels uncomfortable, intractable, or overwhelming. The Reconstruction Amendments demand a race-conscious analysis of social justice problems and their remedies. This means that courts cannot be removed from the challenging work of addressing racial injustice, but instead must be willing to honestly consider our nation's history and the ways that inequity persists today. Because if we do not acknowledge our history and its impact on American society, how can we be sure that we will not repeat it? Thank you. So we're going to take a brief 5-minute break, and then we're going to come back for the panel. Thank you, Ever. All right, everybody, we are going to pick back up on the panel. We're going to start with Judge Gardner.
All right, good afternoon, everyone, and Again, I echo the thanks for the district court for this invitation. This is an amazing conference, and I'm going to try to take the example back to my court and see if we can do something like it. So federal courts, as we've just heard, have always been at the forefront in the pursuit of civil rights. Many of us in this room are direct beneficiaries or were inspired by the civil rights litigation which shaped our nation in the mid-20th century. For myself, I was a little black girl growing up in poverty in southern Mississippi. I could never have had the opportunity to attend Brown or Yale, to practice law, to serve as an assistant U.S. attorney or at a firm, to become a federal judge. I couldn't have had the opportunity to do any of those if it hadn't been for the work of people like Fred Gray, who secured my basic right to an equal education, fair housing, and non-discrimination in hiring. Those are three specific ways that this work has directly affected my life. I decided that I wanted to be a federal judge somewhere in elementary school after writing a report about Thurgood Marshall and learning about my personal hero, Constance Baker Motley. Every time my father tells that story, I get younger and younger. One would think I wrote that paper when I was like 3 years old. And while the courts have made some missteps, as noted, in the past, and we certainly will have some in the future, federal courts remain one of the primary avenues for those who are pursuing justice. Not only have the courts held the line and advanced the cause of racial justice, they've also been the arena in which the rights of women, the differently abled, the LGBT community, the poor, and prisoners have been defended and vindicated. While the contours of those rights and those fights, rather, have changed over the years, justice demands that the federal courts continue to be one of the venues where people, all people, can pursue justice. Of course, the federal courts are but one mechanism designed by the founders to ensure justice for all. The creation of laws to secure civil rights is the province of the legislative branch, and the executive branch, of course, is charged with executing those laws. But the courts are no less important as interpreters of the Constitution and those laws. Access to courts is a critical tool for those who seek to secure or ensure equal rights, equal access, and equal treatment. Current trends highlight the importance of the court system and the federal courts in particular today. Civil rights cases constitute 20% of all civil filings in federal district courts in 2022 as of June 30th. That's 20% of all civil cases. This was up from 15% in 2021 and 16% pre-COVID, so that gives you some perspective. This also topped the previous high in 1997, which occurred after an expansion of civil rights laws in the 1990s. After that slew of laws passed, there was a dramatic decrease in the early 2000s. It got down to somewhere around 12 or 13% of cases were civil rights cases, but they began to rebound again in the 2010s. Of course, employment cases continue to be the largest sector of civil rights cases filed in federal court. By about 50% of those cases filed are some type of employment case, be it under Title VII, the ADA, or something along those lines. Those cases are followed by housing, voting rights, and welfare cases. Those are the next three sectors. Now, while the number of housing and welfare cases are expected to remain steady, there is some question of what federal voting rights litigation in federal courts will look like in the wake of recent Supreme Court cases and depending on what the court does coming. And my, of course, learned colleagues will discuss more of that. But the majority of civil rights cases, as we know, are not brought by the government. They're brought by private individuals against one another. Notably, however, because of the Supreme Court's decisions related to Section 1983 litigation, including, there's some discussion next door about qualified immunity. There was a series of cases in which the Supreme Court limited the ability of private lawyers representing litigants to recover and structure attorney's fees, so that has been a deterrent that has sent a lot of what would have been 1983 civil rights litigation, a lot of that is now happening at the state court level because you just simply can't make a living off of it. So a majority of the 1983 cases that we see are by pro se litigants, which has its own set of issues. Interestingly, civil and criminal prosecutions brought by the federal government have, however, increased in recent years. The Assistant Attorney General set forth the priorities of the Civil Rights Division of the Department of Justice, and there's 5 types of cases that they're really pursuing, and that I think in the next few years is going to really kind of drive the cases that we see in federal court. That is police misconduct and pattern and practice cases and investigations. Of course, voting rights enforcement, however that is contoured in the future. Environmental justice is a new area that they're really focusing on because they're beginning to see, or not see, but focus on the fact that environmental justice has a racial basis to it, and a poverty basis. And so looking at that and seeing how different people in those cases are not getting equal access or getting unfair treatment and have all of the attendant issues related to environmental justice. So DOJ is beginning to look at that. And there's also a lot of work going on around anti-redlining. There's an acknowledgement that the federal government, through many of its programs and working in concert with the banks, are a huge cause for the disparity in home ownership and the ability to get business loans. And so there's litigation and work in those areas. And so those cases, we expect to be seeing more of those cases come into federal court in the future. Of course, when we're looking at the police misconduct and pattern and practice, one of the things that we're seeing is the federal, and on the criminal side, we're seeing departments of justice around the nation, even if there are prosecutions on the state side. So for example, if you look at the McMichael case, which was the murder of Ahmaud Arbery, there was a state prosecution there, but the federal government also prosecuted. The same thing with Derek Chauvin. There was a federal and a state. And so that the federal government or the DOJ is no longer kind of stepping back and ceding that land. And so they're continuing to do those types of prosecutions. In Georgia, 2 days ago, a local sheriff who, interestingly, this was his third indictment for 3 different things now. But sheriffs in Georgia, and a sheriff has been known in Georgia to say that, he is the law and he is God and you can't really tell him anything. And oftentimes in the past, some cases would say that. So there was a recent case that was just resolved by a jury in which Victor Hill, who was sheriff, was convicted of excess use of a restraint chair. And so we're seeing, I expect, and having talked to people and looking at the work that the Department of Justice is doing, that those cases will also probably continue to rise in the future. So that's just kind of giving you kind of a snapshot. But while this is just a snapshot of what things look like today, the big picture takeaway is that federal courts remain critical to the continued progression towards justice, but as noted before, federal courts can only take the cases that are brought to us. So it is very important that both the government and private attorneys continue to do that work and do it in federal courts.
Okay, great. Let me go ahead and get started. First of all, I really want to thank the folks who have invited me today. We've talked a lot about courage, and I think that I was as flabbergasted, I think, as the attorney Fred Gray about what am I doing in Rhode Island? What happened? And so it kind of came out of the blue, that invite, and it's such a treasure. It's really a pleasure to be here. And this court and this bar is doing some amazing work. So thank you so much for having me today. So I want to talk a little bit about, we're talking about the federal courts and civil rights, and I want to raise for us, when we think about civil rights, to maybe broaden our perception a little bit about what we're talking about. So we are, logically we think of civil rights as voting and education and employment and housing and environmental issues, things of that nature. But we don't often think of procedure as a form of civil rights. And so this is what I'm inviting us to do, to think about the federal courts and to think about procedure. over time. So I want to flag for us really over the last half century or so, the Supreme Court, the United States Supreme Court has been slowly chipping away at the process by which every day people access the courts and the civil court system to resolve their grievances and to seek remedies. So as we were taught in law school, we have, our access to the courts is by virtue, we have a right by virtue of the Constitution. We always think of our proverbial, right to our day in court, right? We've heard that many times, and where does that come from? So that comes from the Constitution, the notion of due process, right? That we're entitled to due process and access. However, that access, I would say, is increasingly becoming politicized, compromised, and commodified. The court has, in small but really powerful ways, systemically eroded Americans' capacity to protect and enforce substantive rights through this sort of procedural, sort of maze that people are going through here. So this regressive trend, I would say, has been more acute, let's say, the last quarter century. So what's going on? As a result of that, various substantive rights, I would say, are endangered. You can think of consumer rights, environmental rights, constitutional and civil rights. And so my focus is on that one subset of rights, which is federal, statutory, and constitutional civil rights. And I think that focus is warranted not only because of the sort of critical role that they play in American history, but also because in many ways of their precarious future. All right, so here's the pendulum here, and I would say over the last several decades, the pendulum has swung from judicial support for robust private enforcement of federal civil rights to tolerance, if not outright hostility. And so in some ways, as the judge has reminded us, the federal courts are at the frontier of some of the civil rights progress, but then also we've been reminded that they can also be a barrier, right? So this movement, this swing here of the pendulum is what my colleague, Professor Ben Spencer, calls going from a liberal ethos to a restrictive one, right, when it comes to process. So let's think about what's happening kind of in a nutshell, because I've been giving sort of a small window of time to speak here. So in a nutshell, the argument here is that the court has taken away, what they haven't taken away through, let's say, substantive rulings can be taken away through process or procedural rulings, which are purportedly neutral, right? So that neutral language, that sort of dry, technical language can in fact deceive us into thinking that there's nothing to see here, there's nothing going on. So what is going on? So the Supreme Court has made it more difficult for you to get your foot in the courthouse door. Through cramped interpretations of statutes of limitations and more rigorous pleading standard when we think about Twombly and Iqbal. Hopefully I'll get a chance to talk a little bit later in the Q&A about the Tulsa race massacre litigation that I participated in, where statute of limitations was really the barrier that we had to fight very hard against, and what I might suggest in terms of getting around that procedural hurdle. What else is going on? It's more difficult to band together and challenge systemic discrimination through class actions, right? So we're seeing that post-Walmart, that has been significant, and then more difficult to even participate in the civil litigation system altogether as pre-dispute mandatory arbitration agreements are proliferating, forcing people to use an arbitrator or an arbitration and forego their right to go to court in terms of that due process we were talking about. If you want to do anything, right? If you want to get a job, a mortgage, a credit card, a cell phone, whatever, an app, whatever, you name it, you are going to forego your right to court access, right, through pre-dispute compulsory arbitration agreements, which also have embedded in them class action bans. So that makes it, again, more difficult for people who are vulnerable, who have less access to resources, in fact, to band together collectively to fight discrimination. So while any one of these singular developments alone would present, I think, a formidable obstacle for those who are challenging discrimination, it's the confluence of these over the last quarter century that really illustrates a significant shift away from court access and robust law enforcement. So the cumulative effect of the procedural jurisprudence reveals obstructionism. Court obstructionism inconsistent with the rulemaker's priorities, inconsistent with the lawmaker's desire to enforce the substantive rights, right, that they have, and the laws that they have enacted. So why should we care about, and that's the slide on statute of limitations, let me not forget that. All right, the timeliness slide. All right, so why should we care? Why would we care about stricter statute of limitations, higher pleadings bar, more rigorous class certification criteria, employment conditioned upon waiving court access in favor of arbitration? Why is that? So that is because the rules, the federal rules of civil procedure, are meant to protect certain values, right? So they reflect values. And there are values that we acknowledge, I think, and get a lot of attention all the time. Values like efficiency, uniformity, accuracy, predictability. Those are all values, and I think those values are respected. We have other values that are at stake. So one value, and this comes from the rulemakers themselves, is court access, right? That the rules were designed, and from the Constitution, the rules were designed to make it easier to get into the court. The rules were merely a vehicle through which important policies were enforced. So process yielded to substance. Gamesmanship did not bar people from having access or seeking justice, ordinary people from getting that access, or at least that's the goal. Another value that we might want to consider is resolution on the merits. Again, the rulemakers were about how do we get to the merits of a case, sort of this notion of how do we get to this notion of seeking justice. The rulemakers preferred enforcing rule of law over parties who are winning on what they might call a mere technicality, right? And then another value is leveling the playing field. The rules help to put parties who have unequal bargaining power between them on better footing, right? We think of those who don't have the same wealth, who don't have the same power. Procedure in some ways can help do a redistribution of power and reinforce equality between the parties, at least in terms of the civil litigation system. So this idea here is that the rules, in fact, play this democratizing function. And this is noted by and recognized by a number of different scholars. So in addition to the values that are behind process, why else would we care about this? Which is a really good question. So I study this intersection and I think about procedure a lot, but there are so many other things to think about, right, that would be important. Racialized police brutality, right? Sexual violence, inhumane immigration policies, voter suppression, which we'll hear more about, gun violence, mass incarceration, crushing poverty, wealth disparities, not to mention global warming, right? So is that a list or what? So prioritizing civil litigation procedure, it's admittedly difficult until we consider the futility of all these substantive rights if we don't pay attention to procedural protections, right, and what's going on in the court there. So I think there was rarely a time where it feels like civil procedure is the most pressing, but it is clearly a civil rights issue that we need to be thinking about, simply because we may have all these robust substantive rights and claims, which we know are being attacked. But if we have those, if we don't have them, if there's not robust enforcement, right, then or meaningful process, then none of that really does matter. So given today's tumultuous political landscape and turbulent times, I think this is a time to make sure that the civil justice system, at a minimum, is functioning the way it should and enabling civil rights law enforcement. So how did we get here? Let's talk just a little bit about that. This obstructionism that I'm talking about from the Supreme Court is neither absolute nor uniform. And so that makes it hard to address. It's sort of by death by 1,000 cuts, sort of this insidious power of incrementalism. So I take the position that I think we have gotten to a tipping point, right? Sort of the point that, and this is a debate that's going on, right? To what extent is court access a problem? How serious is it? How grave? I take the position that we have gotten to this tipping point, right? That when you saw that pendulum, that maybe we've gotten to the apex of that pendulum, right? And that it needs to swing back. The status quo has gotten to a point where it's no longer acceptable. So I think incrementalism is certainly a part of why we got there. How else did we get here? And when we think about, if we look out, right, wide angle lens, the last 75 years, and as I mentioned, maybe more acutely the last 25 years, we have this pattern emerge of greater number and higher obstacles, higher barriers for court access and merits-based decisions, particularly when it comes to civil rights violations. So these are functioning as Professor Arthur Miller likes to call as stop signs, right, to civil rights claims. So I think how we got here, in addition to that incrementalism I was talking about, is to think about who makes procedural law, right? Who makes procedural law, who enforces it, who interprets it, who teaches it, right? So who are the actors behind the scenes? So let's think a little bit about that. So who makes procedural law? There's that slide again, the Constitutional Convention, all right? They're the folks who designed made the Constitution here. Procedure is governed by the Constitution. It's also governed by, we know, the rule makers, right? The Advisory Committee of the Civil Rules Advisory Committee and the Judicial Conference. This slide, I don't know if you can see it. It explains basically the rulemaking process when we think about the federal rules of civil procedure. So some professors have done some good work to look at what's going on in terms of the composition of the rule makers, the Civil Advisory Committee in particular. And they did a study looking between 1960 to 2014, and they found an overall trend, a steady decline in what are the proposals that are coming before the Civil Rules Advisory Committee. The proposals favoring plaintiffs went from about 87% down to 19% during that period. We know that the Chief Justice appoints those who serve on the Advisory Committee and who serve on the Judicial Conference in general, and that is going to be a select group of judges, lawyers, and academics who basically function independently and outside of the purview of the public's eye. They do participate to some degree in the comment period here. Again, these professors did a study looking at this period from 1971 to 2014 and saw that the committee is primarily made of Republican-appointed judges. They were 70% of Article III judges that sit on the advisory committee were from Republican-appointed. We know they were over twice as likely to serve on the committee and constituted a majority out of the 41 years. They were the majority in 41 years out of the 43-year period of time. Now, obviously, if you're on the committee, you're more likely to be chosen to be the chair of the committee, which holds the power to set the agenda. As it turns out, those members, I mentioned Republican appointed judges, 331 times more likely to be chosen to be the chair of the advisory committee. Not only is the committee dominated by Republican appointed judges, but also by white men. So from 1971 through 2017, white judges were 5 times more likely to be on the committee than those of color. They comprise 89% of judge years and 98% of committee service years and appointments or reappointments. Needless to say, there has never been a person of color who's been the chair of the advisory committee. So we have this lack of diversity here, political and demographic diversity, when it comes to the rule makers. What about, back to this question. Once we go again, we think about procedure, who practices, interprets, and teaches procedural law. Sort of a quick look at some of the demographics will tell us, certainly when we think about folks of color making only 27% of Article III judges, 20% of state court judges, folks of color, 21% of full-time law professors, and only 10% of partners at law firms. If we look at the gender gap, we also see while women make up 50% of the population, they only make up 30% of all lawyers, 34% of Article III judges, 30% of state court judges, and about 26% of partners at law firms. What about those of us who teach civil procedure? This slide is a slide of folks who are authors of some of the premier civil procedure case books, right, that most of the students are using across the country. Perfectly great group, right? Some of them I, inspired by them. You'll see Arthur Miller in the middle. So great group as individuals, right? Now, whose voices are missing, right? We just saw the picture of this is our major casebook authors. I want you to take a look at this slide. This slide, right, this is myself and 40 scholars from all over the country have contributed essays to a book about civil procedure, critical perspectives on civil procedure on every single component when you think about procedure. And so, not that I'm trying to sell my book, but maybe I should. This is it. Okay, so take a look at these authors and think about what you saw a moment ago. So these are the voices that are missing from the conversation when we think about civil procedure. And we were talking earlier today about, I think it was at the CRT panel, how could you tuck these things into your regular doctrinal classes? This is a supplement, this can be a supplement for civil procedure. We have critical race theory, critical feminist theory, critical queer theory, social science, empirical data, history, all from different perspectives, analyzing some dimension, some component of civil procedure from sort of beginning to end. And so these are the voices that are missing from the conversation. If we included them, how would we think about procedure? What would we actually study and be thinking about? So I've talked a little bit about the perspectives they bring as well. You're welcome we could talk about that quite a bit. All right, so I'm just going to end here about the importance of sort of hearing all voices and hearing the whole story. I think we talked about narratives earlier. What are the narratives? What are the counter narratives that are missing? When we think about the civil court system, it's held up. We think about justice and due process. Everyone sort of gets their day in court. But we know that reality falls short of that, and the voices that are missing here for particular groups, so indigenous people, people of color, immigrants, prisoners, women, people with disabilities, LGBTQ folk. Here, sometimes those court decisions and even the rules themselves, in fact, are instruments of subordination, right? And so we want to give some thought to that as well. So I think I will stop there, but just invite people to think about that, and maybe we can talk a little bit more about how procedure in fact, impacted the Tulsa case, because that's come up a couple of times. Okay, thank you.
Hi, everybody. First of all, I'd like to echo the thanks that my colleagues have made to the Rhode Island District Court. This is really one of the best convenings of this sort I've ever been to. I'm humbled not only by following Fred Gray, but by following all of my colleagues here and the wonderful critical race theory panel that I heard this morning, which was spectacular. Although I've practiced for almost 50 years, this supposed to be a gasp saying, really? I've only been in this universe deeply enmeshed in voting rights for about the last 10 years. But my being part of this universe is really reflective of the organization that I'm a part of, the Lawyers Committee for Civil Rights Under Law. The history of that organization is kind of interesting. In 1963, President Kennedy called about 240 members of the private bar into the East Room of the White House, sat them down and said, it's about time you all started to do pro bono civil rights law. And that, as a result of that, the Lawyers Committee was formed. It also kind of explains this awful name that we have of Lawyers Committee, and not only that, but they doubled down to make sure that you understood it was under law. I never quite got that. But the model of the organization is to leverage the staff with the resources and power and money of the private bar. And I actually started to work with the Lawyers Committee when I was at my prior firm, Deckert, and I was asked by the pro bono partner if I wanted to handle a voting rights case. I said sure, and it turned out to be the Texas voter ID case. And then a few years after that, when I retired and my wife told me in no uncertain terms that I wasn't going to sit home, I went down to Washington and have been working full time for the Lawyers Committee since then. And I came at an interesting time, and I'm going to be something of I'll call it a Donald Downer, but it was a time when there was an increasing narrowing of the protections for voters in the federal court system. In 2013, the Supreme Court issued the decision in Shelby County versus Holder, and that decision, of course, gutted Section 5 of the Voting Rights Act, and that was a section that subjected those jurisdictions with a demonstrated history of racial discrimination in voting to the requirement that they couldn't implement any changes in voting practices or procedures without first getting approval from either the Attorney General or from a 3-judge panel in the United States District Court for the District of Columbia. That was a pretty bad decision. It removed the protections of having noticed that something was going to happen in terms of changes in voting rights, and it allowed those changes to be implemented without any opportunity really to stop them. Now, in that decision, of course, Chief Justice Roberts alluded to the fact, well, Section 2 is still there, and this decision does not affect Section 2. Well, then they got to affecting Section 2 in the Brnovich versus Democratic National Committee case, which came out in 2021. It was the first time, I think, in decades that the Supreme Court had before it a case dealing with vote denial claims under the results prong of Section 2 of the Voting Rights Act, which essentially says, as Professor McClellan alluded to, that states are prohibited from discriminating against voters of color in a way that results in their having less of an opportunity to participate equally in the political system. And in the Brnovich case, the Supreme Court, all of a sudden, I could say out of whole cloth, created what it called guideposts, which it said should govern future Section 2 cases. And for example, one of these guideposts was, well, you should take into consideration whether the practice that's being challenged was a practice that was being used in 1982 when the Voting Rights Act was last comprehensively amended. All of this made it much more difficult, it appears, for plaintiffs to challenge vote denial, to challenge voter suppression issues under Section 2 of the Voting Rights Act. And in 2019, the Supreme Court issued its decision in Rucho versus Common Cause. And that's a decision that held that partisan gerrymandering claims were not justiciable in federal court because the court said they were not judicially manageable standards. And that effectively closed the door on partisan gerrymandering claims in federal court. But Chief Justice Roberts, in the opinion, said, don't worry, you have state courts. Well, for the rest of my talk today, I'm going to talk about that and 3 other issues, which unfortunately kind of result in a feeling, and I'll try to get you out of it, but maybe not, that things are pretty bad and they could get worse in terms of voting rights in our federal court system. The first issue, and actually I forgot that I had a PowerPoint because actually last night I was having dinner with Suzette and with Cara, with the judge, and they said, you have a PowerPoint? I said, no, and they expressed surprise. So today at one of the breaks I put together this pretty skimpy PowerPoint. So we'll flash it, we'll go right by my first slide. The next slide is dealing with the first issue I want to talk about, which is the Purcell issue. And it comes out of the case of Purcell versus Gonzalez, which was a 2006 case issued, I think Justice Kennedy issued the decision. And at the time, on its face, it didn't seem like the biggest deal in the world. There, the the lower court had issued an injunction. I think it was some sort of voter ID case. It enjoined that. But the injunction occurred 2 weeks before the election. The injunction was issued 2 weeks before the election. And the court said, you know, in election cases, we have to be careful because injunctions could lead to voter confusion, it could lead to administrative burden. So you have to take that into consideration. It's not all that far from basic equitable principles of balancing the equities and looking at what the burden could be on a defendant of a preliminary injunction, that sort of thing. Unfortunately, since then, the courts have applied Purcell over and over again in ways that are so ubiquitous that it's basically become a verb among voting rights attorneys that, we've been Purcelled, we don't want to be Purcelled. It's like Googled or Xeroxed or for those of you of a certain vintage, Shept. I don't know how many of you remember that. In any event, it really is it's a big thing because it's been applied not only where there's 2 weeks before an election, but as much as 2 months before an election. The Malveaux versus Milligan case that Professor McClellan talked about. It was stayed partially on Purcell grounds. Now, Justice Kavanaugh, who is one of the, I guess he's probably the jurist who has written the most about the Purcell doctrine. In his separate opinion in Purcell, he actually said courts should not apply this in a knee-jerk fashion. There are certain factors that can be applied that can result in exceptions from application of the Purcell doctrine, and one of them was the strength of the plaintiff's case. Unfortunately, the courts don't seem to be listening to that. We've had several cases, all of us in this universe have had several cases where we have proved probability of success on the merits, yet the injunction was denied on Purcell grounds. It happened in Georgia twice. It happened in the Georgia redistricting case where the plaintiffs had proved to the court's satisfaction of probability of success on the merits that there was a violation of Section 2 in the redistricting. Court said, I think there's a Purcell problem. It happened in a case where we're litigating on SB 202, which is this omnibus voter suppression bill that Georgia enacted. And one of the provisions there deals with prohibition against the provision of food and water to people who are waiting in line. And there, the judge had found that we had a probability of success on the merits on the restriction of providing food and water to vote within 25 feet of any voter. Yet, on Purcell grounds, it was denied. So this is a serious problem. I think it has a chilling effect on plaintiffs in terms of deciding whether or not they want to expend resources to deal with preliminary injunction issues. But worse, it virtually guarantees that unlawful and unconstitutionally, presumptively unlawful and unconstitutional actions, because there's a finding of probability of success on the merits, are going to stay in effect for at least one election cycle. That's pretty bad. So that's the first issue that I want to talk about. The second is Malveaux versus Milligan. I really thank Professor McClellan for saving me the time of having to go into the case in depth, but that was the Alabama redistricting case. And it's a case which raises an issue as to the vitality of a prior case called Thornburg versus Jingles. And I want to give a quick primer on vote dilution cases because this was a vote dilution case. I'll also just mention in passing there seems to be a real split between conservative jurists and less conservative jurists on how to pronounce the name of Thornburg versus Jingles. If you listen to the argument, you heard Justice Alito calling it Gingles, yet Justice Kagan, rightly, I believe, called it Jingles, which kind of does roll off the tongue a little more easily than Gingles does. In any event, I digress. In Thornburg versus Jingles, which was a 1986 case dealing with vote dilution. What is vote dilution? Vote dilution is essentially white majorities drawing lines, district lines, in such a way that the votes of minority populations are essentially given less weight than the votes of white populations. And that occurs when black populations, for example, are packed into districts. It occurs when black populations and other voters of color are spread around districts in such a way as to dilute their votes. In Thornburg versus Jingles, the court said, well, before a plaintiff can even come into court to bring this case, we're going to set forth 3 preconditions. And the first precondition is that the plaintiff must demonstrate that they can draw a map that contains a majority-minority district that's reasonably compact. That's number 1. And number 2, that the minority population that's an issue in the case votes cohesively for candidates of their choice. And number 3, that the white population votes as a block to usually prevent the minority population from electing candidates of their choice. Now, that doesn't prove the case. That just allows the plaintiff to come into court to get by a motion to dismiss. You prove the case by proving that the totality of the circumstances, which include things like the history of voting discrimination in the jurisdiction, that includes things like the effects of socioeconomic discrimination on voting in the jurisdiction, or how many minority candidates have been elected over the years, that sort of thing. If you put together that whole picture, then you might be able to prove a Section 2 vote dilution case once you get by the jingles factors. Now, the Milligan case concerns the first jingles factor, because there, as Professor McClellan said, the plaintiffs were arguing that because plaintiff's map essentially was infused with race, that therefore it violates equal protection. And it was interesting because Professor Corbato this morning raised this issue, and I don't know if he was thinking precisely of Milligan, but this was a Milligan issue, that it's really strange that there are forces who are saying, oh, we're going to use the Equal Protection Clause to stop minority plaintiffs, voters of color, from getting a remedy when there's discrimination. And that's basically what the issue is in Milligan. Alabama is basically saying you can't use race to draw the demonstrative majority-minority district, when the Supreme Court said, well, you have to use race to draw the majority-minority district in order to prove that there's a chance of a remedy. So this is an important case, because if, there's a slippery slope. Because if the court buys the defendant's argument in that case, you could see a situation where it's going to become, as in Brnovich, hard to prove vote dilution cases under Section 2, vote denial cases under Section 2, hard to prove vote dilution cases under Section 2. So we'll probably be talking more about Milligan in the question and answer period. Case to watch. Third case, Moore versus Harper. This case can be argued on December 7th. Remember before I said Rucho versus Common Cause, the court said federal courts can no longer hear more partisan gerrymandering cases? This is a partisan gerrymandering case from the Supreme Court of North Carolina, which applied the North Carolina constitutional provision that would prohibit unreasonable partisan gerrymandering. Sounds like the sort of thing that the court in Rucho said should be done at the state level. Well, here we have what's called, people call it the independent state legislature theory. And I know there was a question this morning at the critical race theory session when a gentleman asked, well, why are you calling it a theory? Because theory really is a pretty good thing. I mean, gravity is a theory. And I don't want to dignify the independent state legislature thing by calling it a theory. The independent state legislature notion essentially says that because in Article 1, Section 4 of the U.S. Constitution, the Elections Clause, that state legislatures have the power to set time, place, and manner of congressional elections subject to Congress saying otherwise, that means the state legislature and only the state legislature. Not the state court, not a state executive acting under emergency powers, but not a state court applying a state constitution. I mean, it's outrageous, it's never been accepted, but there are 4 justices who have indicated in separate opinions in their shadow docket, Kavanaugh and Alito and Thomas and Gorsuch, that they think this theory, this notion, may have legs. We at the Lawyers Committee and along with a whole bunch of other groups, filed our amicus brief just 2 days ago. In our brief, which was joined in by, I think, 13 or 14 other civil rights and social justice organizations, we argue that this goes against the grain of basic notions of judicial review. In Marbury versus Madison, and I think earlier today someone introduced John Marshall as one of the people here. I was pretty impressed. In any event, in Marbury versus Madison, the court said that any government that structures itself along the same lines as the federal government with tripartite system and checks and balances, that government, in that government, the last word on what's lawful or not are the courts. But apparently, if this notion is accepted, that's not good enough. So it is dangerous. And quite frankly, it also goes against basic tenets of federalism, not recognizing that the states have chosen to set up their structures in that way. So that's another thing to watch. And lastly, and this is kind of shocking to me that we really have to be discussing this, whether there's a private right of action under Section 2 of the Voting Rights Act. This is an issue that, the Voting Rights Act has been in place for 60 years almost. And in that time, I think there's only one case that addresses this issue, that one defendant out of the thousands of defendants who've been sued under Section 2 of the Voting Rights Act had the temerity to raise the issue that there's no private right of action, and it was shut down some years ago by the Sixth Circuit. Yet, about 2 years ago, Justice Gorsuch indicated that he thought this was an open issue. And soon after that, Judge Radowski in the District of Arkansas issued a decision acting sua sponte. The defendants had not even raised the issue themselves. Acting sua sponte issued an opinion saying there's no private right of action under Section 2 of the Voting Rights Act. Since that time, and he did that on what we think is a constrained reading of the leading case of Alexander versus Sandoval, which sets the standards for whether there's an implied private right of action. There's clearly a private right under Section 2, and quite frankly, there's clearly a private remedy. For example, one provision of the Voting Rights Act says that prevailing parties other than the United States have the right to fees. Well, that kind of tells you that they assumed that private parties were going to be suing. Anyway, that case is up before the Eighth Circuit. In Georgia, I argued actually about a month and a half ago, and actually we won. The motion to dismiss on this grounds was denied in our Georgia redistricting suit. In Texas redistricting, the three-judge panel there denied it. So, but we think we're in good shape, but we shouldn't be talking about this. That's what is so shocking. So. Here we are. We're in a situation where states, as all of you know, have taken upon themselves to enact statutes in Texas, in Georgia, in Arizona, and other states that make it more difficult for voters of color to vote. And they do this just at the time that voters of color are using additional and alternative means of voting. Absentee ballots, which in the past white voters had used more than black voters and other voters of color. All of a sudden, we're going to make it harder to vote by absentee ballot. Early voting, the same thing. Use of drop boxes, the same thing. We need these protections. And just when we need these protections, the court is making it more and more difficult in virtually every which way. And I don't want to end on this note because we shouldn't, because we know that we've been here before. And Zach started off by reading from the introduction to this session about the arc of the moral universe being one but pointing to justice. And quite frankly, we cannot say that enough, because that's what this is all about. Thank you very much.
Okay, I know we're short on time. We're going to try to just get a brief question into each panelist. So if we could just pick up where you left off, Ezra. You were at the arguments from Merrill. What were your reactions?
I'd like to, oops, am I on? Oops, I'll take that. I'd like to say I was at the argument. I was at the courthouse, and I couldn't get in. It was really strange. They only let in 18 people, 18 lawyers this time, and they shut down the lawyers' lounge because they're now streaming. But I did listen to the argument. And I actually came away from that argument feeling much better than I thought going into the argument. First, I thought the three advocates for the plaintiff side were just spectacular. They did a great job. I thought that the Solicitor General of Alabama really took some turns in his argument that even the court called him on, saying, well, we thought this argument was all about the use of ensemble maps, and you're not saying that. And he said, that's right, but later on he said it was. If I were to predict what were to happen, I probably shouldn't. But I think there are going to be three basic opinions. I think Alito, Thomas, and Gorsuch will write one and probably two opinions, because Gorsuch and Thomas always dissent on Section 2 vote dilution cases, saying Section 2 doesn't cover vote dilution. Yeah, okay. Then I think that there'll be a Kagan, a Sotomayor, and Judge Jackson, I'm sorry. Of course, boy, and it was so moving to hear her, and I'm so glad that Professor McClellan played that clip. She was just spectacular at the argument. And then I think the opinion of the court is going to be written by Kavanaugh or Barrett, with Roberts joining. If I were to predict, I think there's a good chance it's going to be a narrow opinion. It's either going to be a narrow reversal or a narrow win. Quite frankly, I think they have a hard, and the narrow, it's going to center on whether or not there was compliance with traditional districting principles in the drawing of the map. I don't see how they get around Rule 52 if they go that way. I mean, there were facts that were found after trial on the preliminary injunction. It would seem that those facts finding have to be given deference. But strange things happen in that court.
So to Professor Malveaux, I don't want us to lose the chance to hear about your experiencing litigating the Tulsa Race Massacre. Could you speak a little bit about that?
Sure, thank you. I know we don't have much time. I think I just wanted to mention, it sounds like people are already pretty familiar with the Tulsa Race Massacre, so I don't need to share that. It's come up a couple of times in our sessions. I wanted to raise three sort of procedural things when I'm encouraging people to think creatively about procedure and how it is that the courts use procedure to sort of silence voices. You might not know that the litigation that we brought, this was about 20 years ago. I was part of a team, fantastic team, of folks who brought the first and only constitutional law case on behalf of the victims of the Tulsa Race Massacre. So for our elder folks, Johnny Cochran, right, Charles Ogletree, Eddie Faye Gates, Cohen Milstein, a bunch of, Adjoa, a variety of folks who were, John Hope Franklin, my God, I mean, just rock stars. So this group came together and challenged the government's participation in the Tulsa Race Massacre, right? So this had been buried for 75 years. There was a bipartisan commission that did an investigation, lasted about 4 years, and unearthed about 10,000 documents, did interviews of hundreds of people, historians, archaeologists, archivists, lawyers, scholars, everyone sort of came together and unearthed the fact that the government had participated in the, armed and deputized members of the white mob that destroyed the one of the most successful black communities in the country. So this led to one of the worst racial massacres in U.S. history. So when they learned about the government's participation in the massacre, we were then able to bring a constitutional law claim of violation of equal protection against the government. And then we basically did not prevail because of statute of limitations. We had a 2-year statute of limitations. So the expectation was that the victims of this massacre would have pulled it together and in 1923 brought their claim. So we made arguments based on equitable reasons why the statute of limitations should be told. And this is where I think federal judges have a lot of power and discretion that they may not recognize. They need to be thinking courageously, need to be thinking creatively about how is it that we let these sorts of claims go forward. We got jammed up because of sort of three concepts: accrual, equitable estoppel, and equitable tolling. Accrual being when do you have a claim, right? And you know that. But from the government's vantage point, it was like, well, you knew you were injured. You bring your claim the date that you realized you were injured or should have known that you were injured, right? And saw it in a very individualistic way. We saw this as a systemic issue that the government participated in, did not know about that constitutional violation until, 75 years in when this report came out. They're sort of seeing it as a couple of bad apples, right? Individual bad actors who injured people, and therefore they should have known and been able to bring the suit on time. So that sort of notion of accrual, the notion of equitable estoppel, allowing the defendant, the government, to make the statute of limitations argument as a defense, even though they fraudulently concealed their participation. Fraudulent concealment, again, is one of those arguments that should overcome reliance on the statute of limitations. And then finally, equitable tolling, right? Equitable tolling, for reasons when there are extraordinary circumstances, you should be able to toll the statute of limitations. Here are the extraordinary circumstances being the government from top to bottom infected by the Ku Klux Klan, the police, the fire department, the sheriff, the mayor, the congressional representatives, the judges, right? So there's no way that you're going to get a fair hearing in a circumstance like that, where you literally have the government participating in one of the worst racial massacres in U.S. history. To the judge's credit, we were able to toll the statute of limitations for about 40 years, up to the 1960s, when the court said, well, the Jim Crow is over, right? You have civil rights statutes, laws that are in place. It's over. It's done. And we know that it's not done. We know that the moment you pass civil rights legislation doesn't mean either, you didn't know that the government participated in it, but you also don't overcome the trauma, right? The folks probably saw last year for the centennial, there are 3 living survivors of the Tulsa Race Massacre, and they testified before Congress. And they tell you today they can see people getting shot. They can see the bodies, right? They can hear the screams. They can smell the fire. They experience those things even today. So that it's not a simple answer, right? Once you have sort of de jure, that you don't have real trauma and things that stop people from being able to bring that litigation. So I raise that just because I think it's an example of how something as innocuous as a statute of limitations, right, can really stop litigation from going forward, can stop restitution and voices being heard. So urging, again, the courts to be creative and courageous in their work. And we have a wonderful example of that here. So maybe I'm going to leave this for you to end if you I think, had the last maybe word on this panel. So I'll turn it to you.
Well, thank you. And one of the questions that is here that is a question of what is judicial courage? Courage often is, we've got extraordinary courage of that person rushing into a fire. Into a burning building to pull someone out. Judges are not asked to do that. Judges are asked to do our job, to uphold the oath that we took. And there are examples of judicial courage. Frank Johnson. The seat of our court is Judge Boodle. And these are judges who saw the law and knew that they had to do what's right, but were doing it in the face of societal pressure, oftentimes physical danger, and said, I understand that my life is in danger. I understand that I may never get to walk in my community again, but I took an oath to do what was right, and I'm not going to look for a procedural hurdle. I'm not going to look for a way that I can ease out of doing it. And that, I think, is what judicial courage is. It's not rushing into a burning building. We are not heroes. But it's saying, I took an oath, I've got a job to do, and I'm not going to try to figure out how to get out of it. I think that's the charge to keep. I'm the daughter of 2 Methodist ministers, so that's the charge to keep that we have, and I think we've seen it happen, and I think we're going to, going forward, have to count on a lot of judges to continue to exhibit that.
Thank you.